if they're going to go down this independent investigation route. As an aside, I know some people write to the California State Bar. If it makes you feel good, do it. The California State Bar just tosses those. You does not have a license in California. The California State Bar is not going to do anything. That's just the way that piece works. I want to get to the merits in a minute. I want to raise a significant procedural item. Pennsylvania has a 4-year statute of limitation for professional discipline. It's told sometimes that there was concealing. I don't think there was concealing here, but if you're going to push, later on we talk about what you can push for, you're going to have to understand that issue in the Pennsylvania context. All right, then there's reciprocal discipline, and that is, for example, John, you were convicted or subject to professional discipline elsewhere, the State Bar of Pennsylvania could then simply, sort of as collateral estoppel, impose a discipline on its own. Will there be, I would ask, is there going to be an international criminal conviction? Would the State Bar of Pennsylvania apply that? I don't have time to discuss that. Will the DOJ take definitive action? No, the DOJ is going to come out with a report. I'm going to come to that report in a minute. That report is really going to define the field. So if you're into this issue and you care about it, you've got to read the DOJ report when it comes out. It's been leaked a little bit. All right, now let's talk about, so that's the procedural. Let's talk about the ethical failings. Whenever we look at the ethical failings, we have to say, who's the client, what was the role? Otherwise, we don't know where we are. It's notoriously difficult to define the client for government lawyers. Sometimes you'll hear people say, well, justice is the client, or the people are the client. Probably not. If you're going to make it stick in a court of law, it's probably the executive branch. But bear in mind, it's not George Bush. It's not the guy. It's not your boss. It's the office that is going to be the client in this situation, or the organization. And I think the executive branch is going to be the client here, given the OLC. Certainly not Cheney, certainly not Addington. A lot of this was driven by Addington, as was pointed out earlier. Next question, does the government lawyer have a higher calling? Yes, all the case law says so. What does that really mean? That can be very elusive in terms of specifically how government lawyers should analyze an issue as opposed to private practice lawyers. What's the role of the OLC? The Attorney General has delegated his or her authority to the OLC for most legal issues, and the OLC can bind everyone in the executive branch except the president. But the OLC does several different things. It sort of gives advice on the range of stuff that a particular executive branch can do, like a typical counselor would do in private practice. But also can definitively settle a point of law when there's a dispute within the executive branch. It almost smacks of judicial ethics. When you hear some of the people from the Clinton era, and even from the Bush era, who don't like what you did, they say there's an element of judicial ethics that was violated here. And third, they do allow members of the executive branch to rely upon advice of counsel. So this is the question, was this memo a shield for what everyone knew was torture? Because they would use it as a shield of reliance. I don't have time to read all the quotes from Jack Goldsmith, but I'll read one. Conservative, this is the fellow at Harvard that Professor Sims talked about. He said about the OLC, the unusual pressures on the OLC, the office's pro-president disposition, the lack of real oversight may seem to belie the notion that the OLC can bind the president to the rule of law. This is where the cultural norms in the office become critical. Most important are the norms of detachment, professional integrity that permeate the OLC and that transcend particular administrations. And here, I think, is the real ethical failure. But Jack Goldsmith's, I think, accurate description of the role, it's going to be tough to find in the ethics rules. All right, now let's get to the 3 possible ethics violations. Number 1, under Rule 1.2d, did John Yu and other OLC lawyers counsel and assist a client to commit a crime or fraud? And this is, you may have heard this phrase, the common plan. This is the big picture conspiracy. You understood what was afoot. You understood with the particularly tough cases of high value, they wanted to torture. You understood that they were looking to you for a green light. So you participated fully. You facilitated, aided and abetted the big picture of what reasonably happened thereafter, including the waterboarding, which most people would say is torture. So that's the big argument. And I think if you want to push this forward, bear in mind there's a big argument. a commitment to a common scheme. Later we'll talk about the failings of the memo, and I agree about the failings of the memo, but don't forget, prosecutors and plaintiffs' lawyers know that paint the big conspiracy, it can be much harder for the other side to defend. That was number one, facilitation and assistance for a client to commit a crime of fraud. And by the way, I should say in Rule 1.2d, 1.2d says that you can help a client understand the limits of the law, but you can't help them violate the law with impunity. So there's a balancing there. And the notion that this memo was an attempt to help the client violate the law with impunity is what Yu's critics will be pushing. Okay, that's 1.2. One last comment on that. Anthony Lewis, of course, famous lawyer commentator, wrote, these memos read like the advice of a mob lawyer to a mafia don on how to skirt the law and stay out of prison. Avoiding prosecution is literally the theme of the memorandum. All right, I'll move that from that first issue, second to competence. The odd thing is I'd like to hear from both sides as I form my opinion. I can't find anyone who says the memo is competent. I mean, literally, but if there's a learned person out there I'm unaware of, send me an email. Everyone who's commented on the competence of the memo has been critical of it, without exception, to my knowledge. I've looked hard.
Cheney.
Fair enough. Didn't cite Youngstown Steel. Now he's going to say Youngstown Steel was only for domestic use of presidential power, and that position of the OLC goes back many years. Didn't cite the provisions of the Constitution Calgary mentioned. Didn't address what courts, foreign and domestic, would say torture is. There's just a lot of stuff missing. What is there? Kind of over-reliance on a bizarre healthcare statute I think everyone knows was not germane. So there's no craftsmanship, no quality to it. Which raises the question, was it simply bad lawyering? Was it bad lawyering because it was a commitment to a larger common scheme? Certainly competence, though, 1.1, the memos have been slammed on that grounds. It's very rare to prosecute someone for a single act of incompetence. That's why I still think the larger theory might go better. Next, Rule 2.1, independent judgment. This is a short rule, but there's a bunch of different notions crammed in there. Number one, you have to give candid advice. So the question is, did John Yu actually believe what he put on the paper? We seem to say things like that before his stint at the OLC, and during and after. Now, there are some people who think he didn't believe a word of it, but at least he's been consistent. So I don't think necessarily he was of two minds. It's possible he knew that this was very aggressive advice, but he kind of believed it and didn't share the fact that it was aggressive. And maybe you can work that into a 2.1 argument. Second, it's got to be independent advice. This is going to be very interesting when the DOJ report comes out, because it's been leaked that people in Cheney's staff, essentially Addington, was steering the outcome of the memo with emails, was seeing the draft, and was affecting it as it went forward. Now, we're not allowed to simply tell the client what they want to hear. And so this email traffic, when the report comes out, read it closely and see if it was truly independent advice or if you just put down what the client was pushing them to say. Next, the rule says that you may but don't have to give larger social context. And I think Alan did a terrific job talking about what the government lawyer can come to bear. There's a counter-argument to some of what Alan said, that the government lawyer is not the elected policy person. They don't do policy. The government lawyers should leave the policy to policy people. And yet the bulk of what Alan said I agree with. And in fact, the rule says that sometimes technical legal advice is inadequate. Well, if there's ever a legal topic where mere technical legal advice is inadequate, I think torture probably would have to be the top of the list. Because the definition of torture and how this plays out is going to turn on public reaction, a reaction of foreign courts. It's going to turn on political reaction. And to not even gesture toward that stuff probably isn't giving the client what they need to understand. Interestingly, there was an earlier memo that John Yu authored, where page after page he pointed out whether or not the Geneva Convention applies, we've always lived up to it for very important political reasons. And he listed historically all the reasons the court had lived up to it. That's sort of larger social context that you will see in a couple of the memos, particularly when other kinds of lawyers got in the loop. You don't see in the torture memos. So the 3 points, the 3 legal issues are, number one, was there a facilitation and assistance of a client in a crime or fraud? Second, was it just incompetent